In this video, we will introduce negligence.
So you arrive at the dealership at 9 a.m. and you get a customer right away that wants to go on a test drive. You get a copy of his driver's license and load the information in your computer and grab the keys to do your test drive. Yeah, you're off. Suddenly, the person doesn't really want a test drive. He wants to steal the car and take you along for the ride. Do you know that not one dealership has anything in place? Nothing for your safety. Most of the time, hours have passed before you're missed. This is actually possible because there are no real-time security measures available. It can be considered negligence to run your car dealership business this way, without having safety measures in place.
But if the parties go to court, we would say that this is a case about negligence. The defendant is being sued for being negligent. Negligence is another name for an unintentional tort. In law school, you'll frequently hear people say that a plaintiff must prove duty, breach, causation, and damages to win a negligence claim. That's a short way of saying that the elements of negligence are the defendant owed a duty of reasonable care to the plaintiff, the defendant breached that duty of reasonable care, and as a result of the breach, the defendant caused damages to the plaintiff.
Hi, it's Wayland, and I'll be talking about the tort of negligence. In determining whether or not a particular person is liable for negligence, we have to show, or the plaintiff has to show, that the defendant breached the applicable standard of care. So the question that we need to consider is, was the defendant careful enough? Or an even more specific question that a court would look at would be, what would a reasonable person do in similar circumstances? Now, so that begs the question, who is this reasonable person? We don't know who exactly this person is. It could be male, it could be female. We don't know what their experience or what their upbringing is, but let's find out some clues that courts have given us as to who is the reasonable person. Now, to be clear, the reasonable person is not the defendant. We are not asking, whether or not the defendant did their best in that particular situation when the accident happened. The legal test that we apply here for standard of care is what's called an objective test and not a subjective test. We're not asking subjectively whether or not the actual person did their best in avoiding or doing their job to avoid the accident. We are asking whether or not a reasonable person would have caused the same accident. Now, in determining what a reasonable person would do in similar circumstances, courts have given us some clues or guidance. So courts have said that a reasonable person takes precautions against foreseeable risks, but not necessarily precautions against every conceivable danger. Another clue that we have from previous court decisions is that a reasonable person considers the likelihood of harm and the potential severity of harm. So a reasonable person would logically sit down and think, how likely is something wrong going to happen, and how severe will be the consequences. And another thing that a reasonable person would do is that a reasonable person would adopt affordable precautions to prevent against mishap or accidents or injury. So a reasonable person does consider the cost. So there is a cost-benefit analysis that a reasonable person would apply. A reasonable person takes risks where social utility is involved. So a reasonable person would take greater risk if it involves an emergency kind of situation where the reasonable person is trying to save someone's life, for example. And related to that is also the sudden peril doctrine, which allows a reasonable person to make mistakes where there are difficult circumstances, especially in an emergency situation. So we cut a person more slack in an emergency situation. If the person being sued for negligence happens to be a professional, such as a lawyer, a doctor, or an accountant, or an engineer, for example, then we don't apply the general standard of a reasonable person, because a reasonable person does not have the expertise or training of any of those professionals. So we apply a higher standard to professionals. The question that we ask is, what would a reasonably competent and experienced professional do in similar circumstances? So who is this reasonable professional? So this reasonable professional is reasonably competent and reasonably experienced. And if whatever level of expertise is being claimed by the professional, if they claim to be a doctor, we hold them to the standard of a reasonable doctor. So even if that person is either exaggerating or just plain lying about being a doctor, if that's what they say they are, we hold them to the standard of a reasonably competent and experienced doctor. Now, if a professional holds himself out to be a specialist, so if a doctor says they are a heart specialist or a cardiologist, then they are held to the higher standard of a reasonably competent and experienced cardiologist, not the standard of a reasonable sort of general practitioner. If we have an inexperienced professional, let's say a lawyer fresh out of law school, we don't cut that person any slack for being inexperienced. We still hold them to the higher standard of being reasonably competent and reasonably experienced. Now, professionals are allowed to make errors of judgment and not be held liable for them. So there is a difference between an error of judgment, and negligence. An error of judgment is where a reasonable professional in that same situation, might have made the same decision. So that would be considered an error of judgment for which there is no liability under negligence. Now, in determining whether someone was reasonably competent and experienced in a particular situation, we have to base it on the information that's reasonably available at the time of the accident. It's always easy to look at the information that comes to light after an accident to assess whether or not someone was negligent or not. That would be an unfair way of assessing negligence. We have to base it on the information that's reasonably available at the time of the accident. If a professional happens to follow approved practice and still the accident happened or someone gets hurt, then usually there's no liability for having followed that standard professional practice. So that standard professional practice is often set by the governing body for a particular profession. As well, sometimes under particular statutes, there are certain requirements that have to be met by a professional. If a professional happens to comply with that statutory standard, that is at least a significant factor in determining that the professional exercised reasonable care and therefore is not liable or has not breached the standard of care.
Now we do. Salesperson Alert Fob. S.A.F.e provides the only immediate real-time security for your sales force and your inventory, and it's a very good benefit for car dealership owners. Our S.A.F.e security device will make your sales force feel more secure when leaving the dealership with a stranger, and you can recover any stolen vehicle with less stress. How does it work?
Salesperson leaves his house, arrives at a car dealership at 9:00 a.m. The salesperson sits at a desk and a customer comes into the car dealership and wants to go on a test drive. At this point, the salesperson gets a copy of the customer's driver's license, makes a copy, and walks it to the sales manager's desk. He proceeds to leave out of the car dealership and gets into a car and then off down the street on a test drive. About 3 miles down the road, the salesperson pulls over and they both get out of the car to exchange places to drive. The customer at this point pulls out a gun on the salesperson, takes his cell phone, and puts the salesperson in the trunk of the car and drives away. Now, back at the dealership goes to the sales manager's desk and realizes that the salesperson has not arrived back at the dealership. Oh no, that phone call you don't want to get! The day starts over, same scenario except this time, When the salesperson leaves the dealership, he has a safe in his hand, and now when they pull over and the customer pulls the gun, he activates the safe by pushing the button. The shot then goes back to the dealership, where the sales manager is looking at the computer screen and the alert pops on the screen. The sales manager calls the salesperson on his cell phone. There's no answer. He then activates the police activation button, and his screen goes to a policeman in a police car with an alert showing up on his computer screen that allows him to follow the car on the map to get to the salesperson. At this point, he pulls over the car, saves the day, puts the criminal in the police car, and saves the salesperson in the trunk. Then the question is asked.
Isn't that awesome? So, is your Salesforce safe? If not, what are you waiting for?